Your ex just told you they're moving to another state with your child next month, and you froze because you didn't know what to say. You didn't know what you could say. And right now, while you're watching this video, the clock is already ticking. If you say the wrong thing, or worse, say nothing at all, you could lose your child to a move that a judge might never reverse. Not because the law wasn't on your side, but because you didn't know how to use it in time. Stay with me, because what I'm about to share with you could be the most important thing you hear this year. Picture this. You pick up the phone on a Tuesday night. It's your ex. The conversation starts normal, something about the weekend schedule, and then, almost casually, they drop it on you. I'm moving to Arizona. I got a new job. Better opportunities. The kids are coming with me. Maybe they say it calmly. Maybe they say it like it's already decided, like it's already done, like your opinion is a formality they've already moved past. Or maybe it's not even a phone call. Maybe it's a text. 3 sentences. No warning, no discussion, just a notification, like you're being informed about a change in the weather. And then the fear kicks in. You think about your child waking up in a house you've never seen, in a city that's 1,400 miles away. You think about holidays. You think about school plays you'll miss and birthday mornings you won't be there for. You think about FaceTime calls replacing bedtime stories. You think, can they actually do this? And then comes the second wave of fear, the one that really gets you. What if they leave before I can stop it? You don't know if you have days. You don't know if you have weeks. You don't even know if they've already booked the moving truck. That paralysis, that feeling of helplessness, is exactly what happens to thousands of parents every single year. And that paralysis is exactly what costs them their case. Because in family law, the window to act is narrow, and the first words out of your mouth and the first documents filed on your behalf can mean the difference between your child staying and your child being gone. Let me tell you what's actually going on when your ex announces a relocation. In most states across the country, if there is an existing custody order, any custody order, the relocating parent cannot simply pack up and leave with your child. They are legally required to provide formal notice, and in many jurisdictions, they are required to get your consent or a judge's approval before that move happens. Keyword, before. But here's the psychological game that plays out in real life. Your ex may not be acting in bad faith, or they may be acting entirely in bad faith. It doesn't matter right now because the effect is the same. They have framed the move as inevitable, as decided, as something you need to react to, rather than something that requires legal permission. They've shifted the burden onto you psychologically. They're betting on a few things. They're betting that you don't know your rights. They're betting that you'll spend the first few days in shock, maybe calling your mother, maybe venting to your friends, maybe going back and forth with them over text trying to negotiate. They're betting that by the time you talk to a lawyer, they'll have a signed lease and a new zip code. And the legal system, as frustrating as this is, often rewards whoever acts first. When a parent relocates with a child without proper notice or approval, it can constitute custodial interference. In serious cases, especially when it crosses state lines, it can even implicate federal law under the Parental Kidnapping Prevention Act. But none of that protection kicks in automatically. You have to trigger it. You have to invoke it. You have to say specific things and do specific things immediately. Here's what most parents do, and I say this with compassion because it's completely understandable. They try to negotiate, they get on the phone, they say things like, "We need to talk about this," or "That doesn't work for me," or "You can't just do that." They spend 3 days going back and forth over text. They ask their ex to be reasonable. They appeal to the relationship they once had. They try to co-parent their way out of a legal crisis. Or they do the other thing. They panic and threaten. They say, "I'll take you to court," or "My lawyer will stop you," but they haven't actually called a lawyer yet. They're hoping the threat alone will work. Neither of these approaches stops the clock. Every day you spend negotiating instead of filing is a day the moving truck gets closer to your driveway. And here's the legal reality that breaks people's hearts when I explain it to them. Once a child has been established in a new location, once they've enrolled in school, made friends, settled into a routine, a judge may look at that situation and decide that disrupting it again is not in the child's best interest, even if the original move was improper. The law has a concept baked into it that we call status quo. Courts are often reluctant to uproot a child's established situation, even when that situation was created illegally. It is not fair, but it is real. So the mistake is not just emotional, it is strategic. Every hour you wait, Your ex is building a new status quo, and every hour you wait, that status quo becomes harder to undo. The second mistake, and this one is just as costly, is what people say in those early conversations. Parents often make admissions without realizing it. They say things that can later be framed as consent, or as indifference, or as acknowledgement that the move was acceptable. A text message that says, "I understand you got a new job," can be twisted into something it was never meant to be. Your words during this window are evidence. Treat them that way. Now, here is what you say, and I want you to understand something before I give you these words. These are not magic spells. They are not a substitute for getting an attorney immediately, but they are the language that begins to legally establish your position and protect your rights from this moment forward. When your ex informs you of their intent to relocate, whether it's by phone, in person, or by text, this is what you say or write. "I do not consent to any relocation of our child. Any move without my written agreement or a court order would violate our existing custody arrangement. I am formally objecting to this relocation, and I will be seeking an emergency order from the court to prevent any move from occurring before a judge has reviewed and modified our parenting plan. Do not relocate our child pending that review." Read that again, memorize it, save it in your phone right now. Let me break down why every single piece of that statement matters. I do not consent. Those 4 words are critical. They eliminate any future argument that you acquiesced, that you knew and said nothing. That silence meant approval. You have now created a clear, documented record that you objected. Violate our existing custody arrangement. This plants a legal flag. You're not saying you're upset. You're saying there is a binding legal instrument, a court order, and a violation of that order has consequences. Emergency order. These 2 words signal that you are not going to wait for a hearing scheduled 6 weeks from now. Emergency motions can be heard in days, sometimes hours. You are putting your ex on notice that you are moving fast. Pending that review. This is key. You're not saying the move can never happen. You're saying it cannot happen unilaterally, without judicial oversight. You're invoking the process that exists to protect both of you, and most importantly, your child. If this conversation happens by phone and you have not yet consulted an attorney, follow up immediately with a text or email. Put it in writing. Start the paper trail. Then, that same day, not tomorrow, not after the weekend, you call a family law attorney and you ask them about filing an emergency motion to prevent relocation, sometimes called an emergency ex parte motion or an emergency temporary restraining order on custody. The exact terminology varies by state. Your attorney will know it, but you need to be in that office or on that phone within 24 hours. Here is the legal architecture behind those words. Most states have relocation statutes that require the relocating parent to provide written notice, often 60 to 90 days in advance, before moving a child a certain distance away. When you formally object within that notice period, you trigger a mandatory hearing. The relocation cannot proceed until a judge rules on it. But here's the thing that changes everything. When you file for emergency relief, you are asking a judge to issue what's called a temporary order preventing the child from being removed from the jurisdiction, from the state, while the case is being decided. This is sometimes called an emergency stay or a writ of any exeat, depending on your jurisdiction. It is a court order that essentially says, nobody goes anywhere until we sort this out. Once that order exists, your ex cannot leave with your child. Period. If they try, they are in contempt of court. If they cross state lines in violation of that order, they may be committing a federal offense. The Uniform Child Custody Jurisdiction and Enforcement Act, which has been adopted in some form by virtually every state, also gives you tools to establish which court has jurisdiction over your child and to prevent another state from being weaponized as a more favorable venue. By stating your objection clearly and immediately, you also protect yourself from the argument that you waived your rights. Courts look at conduct. They look at who acted promptly and who sat on their hands. When you respond with clear documented language and follow it up with immediate legal action, you demonstrate to a judge that you took this seriously from the very first moment. And frankly, sometimes that demonstration alone changes the calculus for the other parent. When they realize you are not going to be managed, not going to be delayed, not going to be worn down, sometimes the relocation plan quietly disappears. I want to be straight with you about something. I am giving you this information because too many parents lose their children to avoidable situations, not because the law abandoned them, but because they didn't know the law was there, ready to help them, in the moments right after they hung up that phone. Family courts have broad authority to protect children from being uprooted unilaterally. Judges understand the harm of removing a child from an involved parent. The law, when properly invoked, takes that seriously. But, and I want you to hear this clearly, the law cannot help you if you don't move. If your ex is planning to relocate and you decide to wait and see how it plays out, you may find yourself watching your child drive away. And once that happens, reversing it becomes exponentially harder and exponentially more expensive. Some parents spend years and tens of thousands of dollars trying to undo a relocation that could have been stopped in its tracks with a single emergency filing. There is no situation in which waiting is the safe play. None. And one more warning. Do not make threats you don't intend to follow through on. If you tell your ex you are going to file for an emergency order, you need to actually file for an emergency order. Idle threats not only fail to protect you, they can make you look unstable or manipulative in front of a judge. Mean what you say, then do it. The legal system is not perfect. It is slow, and it is stressful, and it is expensive in ways that feel deeply unjust when all you want is to be present in your child's life. But it is the system you have. And when you use it correctly, when you invoke it immediately with the right language, with an attorney in your corner, it can and does work. Do not give up your place at the table before the conversation even starts. If you're watching this because you're going through this right now, I hope this gave you something concrete to hold on to, a starting point, a direction. And if you're watching this because you want to be prepared, good. That instinct is everything. The parents who do best in these situations are the ones who knew their rights before they ever had to use them. There's a lot more to the custody conversation that we haven't covered here. What happens at the emergency hearing? How to prove relocation is not in the child's best interest. What best interest of the child actually means in practice, because it's not what most people think. How to handle a situation where your ex has already left, and what legal tools you still have available even then. All of that is on this channel. If this video helped you, subscribe so you don't miss what's coming next. Share it with someone who might be facing something similar, because they may not even know they need this information yet. And if you found this useful, leave a comment below. Tell me your situation. Tell me what questions you still have. I read them, and I use them to figure out exactly what to make next. This is educational information, not legal advice for your specific situation. For that, you need a licensed family law attorney in your state, and based on everything I've just told you, you need them today. Take care of yourself, stay present for your kids, and don't let fear make you freeze when the law is standing right there, ready to help you fight. This content is for educational purposes only and does not constitute legal advice. Laws vary by state and jurisdiction. Please consult a licensed family law attorney for guidance specific to your situation.